Pakistan has passed a major constitutional amendment. And while it touches many areas, the changes to the judiciary have become the most controversial. The reaction has been swift and serious. Senior judges have resigned, bar councils have protested, and constitutional experts are warning that the amendment may have quietly altered the balance of power in ways the public has not yet fully grasped. With the debate discharged, it becomes essential to calmly examine what has been done, how it affects the ordinary citizens, and what kind of future these changes might produce over the next 1 to 2 years. The amendment's most transformative feature is the creation of a new federal constitutional court, which now holds authority over the most sensitive constitutional matters previously handled by the Supreme Court. This shift has been presented as judicial modernization, a move towards specialization. Yet, the abrupt relocation of constitutional interpretation from a long-established, time-tested institution to a newly formed court raises immediate concerns about intent and consequences. When the architecture of power changes this suddenly, people wonder what prompted the urgency. Those concerns deepen when looking at how the new court was filled. The inaugural judges, including the Chief Justice, were appointed by the President on the advice of the Prime Minister. There was no transparent selection process, no consultations with the bar councils, no independent screening mechanism, and no explanation for bypassing several senior judges. The opacity surrounding these appointments is what pushed some Supreme Court judges to resign, signaling that the judiciary itself sees the changes not as a reform but as a shift in control. The speed of the amendment only amplifies this unease. Constitutional redesign of this magnitude is typically the result of sustained dialogue, expert debate, and public engagement. Instead, the amendment moved from draft to passage with unusual haste. Such speed rarely aligns with thoughtful reforms. It suggests an intention to lock major structural changes in place before meaningful scrutiny or resistance could materialize. Equally troubling is what the amendment leaves out: safeguards. While the executive's influence over appointments has increased, no new protective mechanisms have been introduced. There is no requirement for bipartisan agreement, no independent vetting panel, no transparent hearings, no publicly codified criteria for who qualifies to interpret the Constitution. This absence of guardrails means future governments, regardless of their ideology, could shape the court in ways that suit their interests. In a country where institutional checks are already fragile, this gap is more than a technical oversight. It is a structural vulnerability. Weakening the Supreme Court's constitutional role carries its own risks. For decades, Supreme Court served as a final guardian of constitutional limits, hearing cases on fundamental rights, governmental overreach, and separation of powers. By transferring these responsibilities elsewhere, the amendment dilutes the stabilizing presence of a historically independent court. Even if the stated intention is administrative efficiency, the practical outcome is a shift in the system's center of gravity away from institutions designed to check power and toward a structure that emerged under heavy executive influence. Judicial independence rarely collapses all at once. It erodes gradually through subtle shifts in structure and influence. This amendment may not immediately dismantle judicial autonomy, but it opens pathways through which independence can weaken quietly and steadily, without triggering dramatic legal crisis. The next 1 to 2 years will be crucial in determining the lasting impact. One possibility is that the Constitutional Court becomes reliably aligned with the executive on politically sensitive matters, from election disputes to fundamental right cases. Another possibility is institutional conflict, as the Supreme Court and Constitutional Court test the boundaries of their respective authorities. Either scenario risks undermining public trust in judiciary. Civil society may also intensify its pushback, questioning the legitimacy of the new court's decisions and challenging the amendment's validity. Rumors add further uncertainty. Some fear the new court could shield powerful institutions from scrutiny or validate controversial actions framed as constitutional. Others worry that politically charged cases will be steered toward a court perceived as more predictable for the executive. Whether these fears are accurate or exaggerated, their widespread circulation reflects a deficit of trust created by an opaque and hurried process. And so, the central question returns sharper than before. Has the Constitution been disarmed? Until the government demonstrates that the new court can operate with genuine independence, transparency, and institutional restraint, this question will continue to shape Pakistan's legal and political landscape.